right, we're going to get started here. And speaking only for myself, I am just so thrilled with the quality of presentation by our panelists. Yesterday, we started with an academic panel looking at broadly innovation and intellectual property issues. Then we had a panel of VCs who focus primarily, I would say, on startups, but I don't want to miscategorize that to the extent that they have broader views. But we were really sort of talking about what's the role of IP in sort of early stage investment. As you saw this morning, we pivoted to quality and litigation, and we actually also had the copyright panel yesterday. Now we are sort of coming back to an industry panel, to I think it's fair to say, with a slightly broader perspective, because you're not all, only focused in one particular industry. You're not all focused in one particular stage of development. And I'm really looking forward to collecting your feedback on what you've heard this morning and your views of innovation and intellectual property within your various industries. So with that, I'd like to introduce Tahir Amin, who is with the Initiative for Medicines, Access, and Knowledge, Patrick Kilbride, who joins us from the U.S. Chamber of Commerce, Barbara Fiacco, who joins us from AIPLA, the American Intellectual Property Law Association, Hans Sauer from Bio, and I will say that I'm getting a flashback to about 10 years ago when Hans and I were on a similar panel looking at biologics issues, and Matthew Schurz from the Computer and Communication Industry Association. So thank you all for your time today, and I'd like to begin with a presentation by Tahir. Thank you.
Thank you. I'm going to speak today with respect to the pharmaceutical sector. So I've just been following some of the panels earlier today and yesterday, and we've heard a lot about, and I'm sure we'll continue to, what I would call innovation welfare, or the welfare of innovation. But I want to address it from, what about the consumer welfare when it comes to intellectual property? And how we can have competition which is not entirely focused on just IP. So I'm going to look at the role of patents or patents. I'm from the UK, so we say patents. And the problem that we have in respect of what I call over-patenting. So what we have done is looked at the top 12 drugs that are sold in the United States, and we looked at the data in terms of number of applications filed and the numbers that are granted. But we also looked at the prices that have happened over the last 6 years with respect to those patenting trends. But just to give you some context, and as I said, I'm going to come from a more consumer welfare perspective because that's also the FTC's role in this conversation. 1 in 4 Americans are having difficulty filling their prescriptions in the United States. The drug pricing issue is the #1 issue for the electorate. And that's not usually the case, it's usually the economy. And this has been going on for the last year. So that's just to give you some context to the data and the issues that I'm going to address. So, as you see with these slides, the drug pricing is set to double by 2025. So this is going to be an ongoing problem. Now, of course, we need innovation, we need new inventions to bring new medicines to the market. But at the same time, with this balance, this delicate balance that we try to achieve with IP, we need competition. And it's self-evident that with more competition, you bring prices down. Now, what we did was to look at the top 12 drugs in the United States, the top 12 drugs that are being sold. And what we found was an enormous amount of patenting activity that is going on in the name of innovation. And many of these patents are well beyond the 20 years, or many of these products are providing potential exclusivities up to nearly 40 years. Now, out of these drugs on the market, I believe only 3 actually have competition to date. So we've seen a 68% price hike over this period. And many of these drugs have been on the market for 15 years and more. And yet we've seen over 100 attempted efforts at getting a patent. Now, particularly, I'm going to drill down on Humira because a lot of people have been asking as well, you know, what does this data mean, and more specifically, more granularly. And we looked at Humira, and one of the arguments that is often made by industry is that many of these patents are filed before the product is approved. So we thought, okay, well, let's have a look at that. And what it shows is 89% of the patents are filed after the first approval. And then with the case of Humira, which is a real poster child for the kind of behavior that's going on, we have 49% which are filed even after the first expiry of the first patent. Now, it would be a coincidence to say that this is not some kind of strategic behavior that is going on by companies in order to preserve their franchises and their life cycle management of products. When we compare it to what's happening in the United States for Humira, to Europe and Japan, we see a far fewer number of patents being issued. Now, is Europe more stringent than the United States when it comes to patents and innovation? That's a debate to be had. But what we're seeing is some of the patenting practices and the procedures that are available at the USPTO seems to encourage this excessive behavior of patenting, all in the name of innovation. Now, there's been a lot of debate about the PTAB, and I just want to touch on a few points here. The PTAB, when it started, did show that there was some correction that was going on, and you see this is slightly out of date in terms of the periods, but initially there was, with respect to Orange Book patents, you had 64% of petitions being instituted. Between February and August, we've seen that drop significantly to 27%. And the same trends show also in terms of getting claims removed. Now, whether you agree with the PTAB or not, I think it's fair to say there's been a chilling effect around the PTAB, particularly following Oil States, the case that was taken to the Supreme Court, for any of you who weren't following that. And really, with a number of the industries who, what you might say, were from the pro-patenting side or the pro-innovation side, really lobbied hard to make the PTAB corrected. And this is the effect that we're seeing with this correction. In fact, the PTAB, in my opinion, and we can talk about this later, hasn't had the chance to settle. So in view of all these trends, we believe that there needs to be some reform. We believe that we really need to revisit what is inventive. I think the language of innovation is important, but I think invention and innovation are 2 different concepts. I'm not going to get into that abstract debate now, but it's something we can talk about. We need to really reduce, and I think eliminate, continuation application, because many of the patents we're seeing stockpiled are because of these continuations, and these are strategic measures that companies use to keep competition at bay. We need to improve the existing IPR system. Unfortunately, as I said, forces have whittled it down, and we are seeing it being narrowed more and more. And we've seen the success of pre-grant oppositions in other countries. I think this can actually encourage competitors to come to market earlier and let the problem solve itself afterwards, rather than the other way around, where we have litigation to solve these issues and people are not getting the medicines that they need. And then finally, specific to the Orange Book, I think there could be some tailoring there. Companies are well known to be listing patents on the Orange Book just to extend litigation. And I think we need to have a bit more of a transparency around this patent dance that happens with biosimilars and biologics. Thank you.
Thank you very much. I think next we'll hear from Hans Sauer.
Good afternoon. On behalf of Bio, I want to thank the FTC and its staff for the opportunity to participate in this hearing. Bio is the nation's largest trade association for the biotech industry. Our industry is largely an industry of small and mid-sized development stage companies, and much of it is not visible to consumers. The vast majority of our members have fewer than 50 employees. and no marketed products yet, and most never will, because product development failures are frequent, they're almost the rule, and the path to market is long. Emerging companies hold more than 70% of the clinical development pipeline for future drugs. Roughly 43% of emerging company clinical programs are partnered with larger pharmaceutical companies, and that demonstrates, I think, to us daily the importance of licensing and the importance of, relatively clear IP rights for the transfer and orderly dissemination of intellectual property as it is relevant to our industry. This is really like a hallmark of how we develop products. Like, we do it very much in our industry through partnering and licensing and tech transfer. And this, in fact, is the predominant way in which patents and IP instruments are being used in our industry. It's not to litigate against people, but it is at the early stage of drug development to be able to attract capital and disseminate technology among different entities in the value chain that are best able to share the burden of cost and risk and of product development. Between 1/2 and 2/3 of new drug applications and biologics license applications submitted to the FDA have small company involvement. The cumulative likelihood, I told you about the risk of failure, right? The cumulative likelihood that a new clinical development candidate will eventually receive FDA approval is less than 10%. Clinical testing and regulatory review consume close to 10 years on average, at out-of-pocket expenditures exceeding $1.3 billion. So despite unfavorable odds and long investment horizons, the U.S. biopharmaceutical industry, however, is highly productive in an international comparison. This is shown in the pie chart. By one measure, more new medicines originate in the United States than in the rest of the world combined over the last decade and a half. Although projected returns on R&D investment in the biopharmaceutical industry have been on the decline, they're currently measured at around 4% per annum. The U.S. biopharmaceutical industry is, this is my proposition to you, by and large doing an effective job at creating new medicines and treatments. We believe this to be attributable to at least a number of factors such as these listed here. Competition in the industry takes many forms. Emerging companies, long before a drug is approved, compete for access to capital and for the attention of development partners. That, too, is competition. Experimental drugs that undergo clinical development compete with each other for scarce clinical resources, for the availability of clinical trial sites or patients who could be recruited into trials. That, too, is competition. And marketed original drugs compete with each other both on value and on price. Many of the products that Mr. Amin showed you earlier actually compete against each other. And at least one had already 2 biosimilar competitors in the market. So there's a lot of competition going on that takes different forms. It is often actually competition with other branded products that drives innovators to add additional features, indications, and clinical studies to their own brand products in an effort to distinguish these products in the marketplace and compete and provide more clinical value to patients and providers and have a distinguishable product in the market. Branded products also compete with each other on price, discounts, and rebates. But to be clear, that kind of competition is between different innovative products that have their own IP portfolios and that have their own patents and that have distinguishable qualities in the marketplace. It's not competition between ever cheaper copies of the same product. That kind of competition is a special feature of the Hatch-Waxman Act, which regulates the approval and market entry of generic drugs. When generic drugs enter the market, you see this on the left-hand diagram, this has been studied, the impact on the original product is profound. Today, and this is the lowest line you see on the left, innovator market share erosion of 80% or more within 3 months are the norm, with 8, 10 or more generic entrants vying for a share of the market. 90% of prescriptions in the United States today are generic. This is the highest generic market penetration rate in the industrialized world, and U.S. payers pay among the lowest generic drug prices anywhere. This form of competition works incredibly well for consumers and payers. So complaints are not that there isn't enough of this kind of competition or that it doesn't work. Complaints are usually about when that competition comes, right? It's the timing and when it occurs. That too has been studied. Over the past 20 years, innovator drugs that experience generic entry, this is kind of funky to read, but if you focus on the black line, for example, you'll see the black line is the number of innovator drugs that experience generic entry in any given year. And the percentage it shows is how many of these innovator drugs that have generic entry actually had an affirmative patent challenge and patent litigation, a challenge to their patents before there was generic entry. Right, a so-called paragraph 4 challenge, which is a unique form of patent validity litigation in the pharmaceutical space. So these patent challenges, as you see from that line, have become increasingly more frequent and come earlier in the market life of the innovator drug. Over the past 20 years, we've gone from about 10% of innovator drugs who experience generic entry after an affirmative patent challenge in district court, this litigation, and we've gone to about 80% in 2014. Right? So the number of patent challenges has gone up, and these challenges come, and that's the other line, much earlier in the life of the innovator drug. So generics are challenging patents much more often and much earlier. What this diagram doesn't tell you, though it tells you something about litigation behavior, it doesn't tell you about when these generics actually come on the market, just like patent numbers don't tell you about how long they stay off the market. That, too, has been studied. The empirical time to generic entry actually has been investigated by several different groups. In this 2015 study, the innovators looked at originator drugs that experienced generic entry over a 12-year period. And consistent with other studies, they report an effective period of market exclusivity of 12.5 years for all agents. The time is somewhat longer for pioneering drugs and tends to be shorter for other kinds of products like second or third in class molecules or drugs that are merely, if you will, new formulations. Again, these types of studies are limited in that they don't tell you about the mechanisms that are in play. So, for example, from these numbers, we don't know if it's attributable to patents or regulatory exclusivity or technical or market factors. The only thing this counts is the day when a new innovator drug enters the market, and then it counts the days until it experiences generic competition. That's how you get to 12.5 years. Yes?
Two things. One, I think we know you have 2 more slides, so we want to let you keep going. But the second is, when we're talking about this past few slides, we're talking about small molecule drugs, right? Just as a
Yes,
point of clarification.
and I need to make that clear, right? Because this is the area where it's been best studied and where behavior is best understood. And I hope to get to that maybe later. It's not about biosimilars. I think those deserve a different conversation. But you're right in pointing that out.
Thank you.
Good. Okay, let me move on. Say a few things about patents. On the topic of patents, now where was I? The number of patents are best understood for small molecules where they are listed in the Orange Book. The number of patents that innovators use to shield generic competition also has changed over time, just like you saw the patent challenge behavior changing over time in the earlier slide. We know that today pharmaceutical innovators do list more patents in the Orange Book. That's a listing of like the relevant patents that cover the drug or methods of using it. I think they list more than twice as much as they did in the 1980s, but the absolute numbers are still small. The reported number, the median number of patents that are listed in the Orange Book for new chemical entities is 4. Right? And the average number is about 5, 5.5. It used to be only 1 to 2 drugs, to 2 patents in the 1980s, so that has increased. But the absolute numbers are still small, and it's not hundreds of patents. And while the Orange Book captures different kinds of patents than what IMAC may have captured, the big difference in numbers is still perplexing, and we're still trying to understand like how these stark differences could arise. It's, for us, it's been difficult to understand. I think some of the data that have been put out, knowing that patent numbers are what they are, at least in the small molecule space, in the 5 to 6 patents per drug range. Okay, finally, right? Time to generic entry. This is another study. It looks not just at average numbers over a 12-year period. This actually measures over time. Drugs that receive generic entry or experience first generic entry over different time cohorts. You see this on the x-axis. And so what the system produces, the Hatch-Waxman system, has been over the past 20 years, ever since people started measuring, is a very, actually surprisingly consistent period of 13.5 years for new chemical entity drugs, from the time they first enter the market to the time when they experience generic competition. And interestingly, and perhaps surprisingly, that time has been stable despite so many other changes in corporate and litigation behavior. Right? I told you about the fact that there are more patent challenges now than there were 20 years ago, that these challenges come earlier. I told you that innovators list more patents than they did in the past. But what the system produces in terms of market exclusivity has been surprisingly stable and hasn't been subject to a lot of change. It's 13.5 years for small molecule drugs. That's what it's been. It hasn't changed. It's not 48 years. It is what it is. We could have a policy debate over whether that time is still appropriate or not. But I want to ground all of us, I think, in this kind of horizon of competition and periods of market exclusivity that the system seems to have produced. On the topic of biosimilars, I think it's very different and too early to say, and I'm going to finish that because I'm not going to go into it. I just want to leave you actually with a reminder that this doesn't tell you much about competition in the biologic space, but it's the best data set we have on small molecule drugs and the behavior of medical innovators. So thanks for that, and we're going to do the rest in discussion.
Terrific. Well, thank you very much. And again, sorry to interrupt, but we want to make sure we have enough time for everyone. So next we'll turn to Matthew Schurz.
Thanks. No slides for me, so I'll just present from here. Thanks. I want to say thank you to our hosts. We appreciate the FTC bringing folks together today to talk about these critical issues. Happy to have the opportunity to explore them. CCIA represents companies that are some of the largest users of the intellectual property system. Worldwide rankings of research and development show U.S. ICT firms having 5 of the top 5 slots for R&D spending. It's on the order of 70 to 80 billion a year, depending on when you count, and a considerable amount of that R&D yields patents, making our constituents some of the biggest users of the patent system. They're also some of the most recognized brands in the world, some of the most trusted institutions among Americans, in fact. And that, of course, has great impact on the brand value. So our constituents also care greatly about trademark. And as many of us probably consume content that's produced or distributed, at least, by some of the firms we represent. And so I'm happy to say that our constituents care greatly about copyright as well. In short, ICT firms are rights holders. They are economically significant rights holders, and they want an IP system that encourages and promotes innovation. So with that in mind, I've got 3, I think, pretty brief points that I'll try and stick to here and explore the rest in discussion. The first is that legislative and judicial changes that have happened in the patent system in recent years have improved the innovation landscape. They have not solved problems, but they have improved conditions. Objections to these reforms are not particularly well-founded. And 3, more needs to be done to promote IP certainty, both in the context of patent and copyright. So on the first one, the first item, these reforms have made differences. The availability of IPRs under the AIA and recent federal court jurisprudence, primarily Alice, were both warranted and actually overdue. The Supreme Court reining things in via Alice had a very positive impact on research and development in the software and internet sectors. We saw it grow at 27%, which was greater than the growth of all other industries. That's research and development spending for software and internet in the year after Alice. And the suggestion that Alice had any negative impact, at least with respect to the software industry, is difficult to reconcile with the stats on so-called unicorn IPOs. These are firms that startups that IPO for greater than $1 billion. That number exploded in 2014 and then doubled the subsequent year in 2015. There's also data that supports the impact of IPR. Since both the AIA and Alice, the AIPLA economic survey shows that the cost of patent litigation has declined substantially. If you look at copyright and trademark litigation as not a perfect control, but a control, that does tick down slightly, but not nearly at the rate that we saw the cost of patent litigation fall. And if you compare the amount of work that's being done in IPRs relative to patent litigation, some rough math could lead to estimates that we've made that over $2 billion in litigation savings have occurred by adjudicating issues in the IPR format. And so based on that data, I think we can clearly say that reversing course on these reforms would negatively affect the industries that depend on this regulatory regime and that have seen the benefits from these recent reforms. My second point that the critics' arguments are not particularly well founded. There's a narrative that the courts have gone after the patent system, and it is true that particularly in the area of 101, the Supreme Court has cut back on excesses that have originated largely with the Federal Circuit. But for every case that you can find where there have been judicial reform of the patent system, you can point to cases like SCA Hygiene on latches or Halo on willfulness or Berkheimer, where wins for plaintiffs have strongly given an advantage to in the litigation context. And so it's not accurate to paint the recent developments in case law as just painting, narrowing patents. Like any area of the law, we see wins and losses that benefit both defendants and plaintiffs, and that's totally appropriate. There is independent research that shows that patent valuations in secondary markets have remained largely unchanged after Alice. I know we have a representative here from the chamber, so that they can respond to my, Patrick can respond to my criticism here, but the chamber's has a study which ranks the US patent system as 13th in the world now, behind Italy, which appears to be largely based on the assessment that having a meaningful 101 and the institution of IPR under the AIA was a bad idea. It cites high volumes of IPRs. As some of the scholars on the first panel this morning noted, that's misstating the frequency at which patents are invalidated by the PTAB. And in fact, several EU countries, which outrank the US in the chamber study, invalidate or modify patents at a higher rate than the PTAB does. So the notion of a regulatory system that's going after patents without cause is highly overstated. In short, I'd say the impact of the reforms we've seen is overstated, and in fact, more needs to be done. Suzanne asked about what we might have taken away from this morning, and I think a lot of the data we saw shows that while there have been some improvement in a number of metrics and indicators that we can look at, these problems have not gone away. They have, in many cases, simply leveled out. Perhaps we have stopped the bleeding, but not treated the underlying wound. So, in more, I think more can be done to achieve certainty for innovators in the patent system, and some of these issues I think actually carry over to the copyright system as well. And the recent Music Modernization Act is a recognition of the fact that uncertainty can impede licensing, and Congress actually stepped forward to try and address that area. I think some parallels could be drawn here, but seeing as how I've exceeded the time I've been given. I'll stop here and we can cover it more in discussion. Thanks.
Thank you very much. Next, I'd like to turn to Barbara Fiacco.
Thank you. Thanks very much for hosting this discussion today. I need to give the obligatory disclaimer. I think I'm the only one on the panel today that needs to do so, but AIPLA is not my full-time employer. I am here speaking on behalf of them today as the first vice president, but my full-time employer is my firm, and I'm not speaking on behalf of my firm nor my firm's clients. So with that, let me introduce you a little bit more to AIPLA. We're a national bar association. We have approximately 13,500 members. We're primarily lawyers engaged in private or corporate practice, in government service, or in academia. We represent a wide and diverse spectrum of individuals, companies, and institutions who are both owners and users of intellectual property, big and small, across all sectors. Our mission includes helping establish and maintain fair, balanced, and effective laws and policies that will stimulate and reward innovation while balancing the public's interests in healthy competition, reasonable costs, and basic fairness. So at the outset, I do want to address the data point that Matt brought up, which is the U.S. Chambers Index, and I won't steal Patrick's thunder, but suffice it to say that AIPLA is concerned with the drop in the U.S.'s ranking in the IP index. It's a disappointing turn of events for a country that's traditionally led the world in this area and has championed intellectual property rights. So in my opening remarks, I want to touch on two things. First, on the importance of IP to U.S. competitiveness and leadership, and then I'll underscore some of the legislative and regulatory changes to the IP landscape, as well as judicial, that we've talked about this morning, and I'm sure this panel will continue. So with respect to intellectual property and the U.S. market and technology leadership and competitiveness, AIPLA firmly believes that in order for the U.S. to maintain competitiveness and leadership in the global marketplace, it's important to support innovation by having a very strong patent system that enables a sustainable return on investment in R&D. Innovators in high-tech industries spend many billions of dollars on high-risk R&D. These innovators face substantial risks that their R&D won't succeed and that their R&D expenses will not be rewarded. Ensuring that we have a strong patent system allows innovators to be confident that they'll be able to obtain a return on their investment if and when they successfully develop those new technologies. And without this promise of a return, there's no incentive to continue investing in R&D and create these technologies. So let me shift now to the current and shifting landscape of U.S. IP law and practice. And I want to touch on a couple of things. First, Section 101 case law. The landscape has clearly changed here, or perhaps I should refer to it as a sea change. In 3 Supreme Court decisions issued between 2010 and 2014, the court distorted patent eligibility determinations under Section 101. Section 101 was really intended to be an enabling provision, identifying particular categories of subject matter that qualified for patent protection. It wasn't intended as a standard to decide whether a particular technological advance should receive patent protection. That's what the remainder of the Patent Act is for. Sections 102, 103, and 112. They were intended to provide the yardstick that judges novelty, non-obviousness, and the sufficiency of the disclosure in the spec and in the claims. The Supreme Court's decisions have blurred these statutory functions, and they've caused significant uncertainty, as we've heard today, and are potentially driving innovation investments abroad. The present uncertainty has weakened our system, and it's discouraged investments in areas ranging from software to life-saving diagnostic tools to therapeutic medicines. The Federal Circuit, the district courts, the PTO, and our members are all struggling to find a principled formula to guide their decision-making. So AIPLA, along with other organizations and businesses, have recognized this significant problem, and we've called for a solution. Over the past year, we were able to reach an agreement with the Intellectual Property Owners Association on a proposed legislative solution to the 101 subject matter eligibility problem. Our proposal provides a clear and objective test that will result in appropriately broad eligibility, including expressly removing considerations of inventiveness from the eligibility determination. We hope that the FTC will take this significant uncertainty into consideration when evaluating the market power or effect associated with patents going forward. Second, I'd also like to address the IPR proceedings by the PTAB, which has also been the subject of discussion by many of today's panelists. It also represents a very significant change in the landscape. Since introduction about 6 years ago, IPR proceedings have been very broadly used, perhaps far more frequently than had been envisioned at the time that the AIA was enacted, in order to challenge patent validity. Some, including some here today, have expressed concern about the balance and the fairness of that procedure. The emergence of the proceedings has dramatically changed U.S. patent enforcement by adding, in effect, a second prong to litigation in many cases. Rather than taking the place of district court litigation as originally intended, it also now allows for serial challenges to the same patents, both in the PTAB and in the courts. So the IPR process has fundamentally changed the calculus of considerations that a patent owner has to consider before pursuing enforcement in the courts. Moreover, as you've heard, in IPRs, the PTAB doesn't presume that a patent is valid. So the presumption of validity that characterized U.S. patent law for decades is significantly limited and weaker today. Other concerns have been expressed about IPRs, such as the difficulty of amending claims during the proceedings and the possibility of serial challenges with no standing requirement. These factors have created a landscape which can place a cloud over a patent for its entire life, leading to the devaluation of patents generally. Third, patent litigation has changed. Over the years, few would dispute that the legal framework for enforcing IP rights has changed dramatically. It's led to some uncertainties and a lack of clarity, as well as some positive outcomes. Examples of that include in the context of injunctive relief. The 2006 eBay decision changed perceptions about the ability of patents to exclude others, changing the calculus, sharply limiting the ability of patent owners to obtain injunctions, and that's impacted enforcement strategy and also some licensing behavior. In light of that case law, the portrayal in the 2017 FTC DOJ licensing guidelines of IP rights as conferring an unbridled power to exclude may no longer be completely accurate. As was also noted this morning, other developments in patent law have changed, negatively impacting the ability of the patent owner to enforce her rights and recuperate investment costs, including the change in venue law, divided infringement law, heightened pleading requirements, and patent exhaustion, to name a few. So in conclusion, over the past 7 years, we've seen legislative, administrative, and judicial trends that have produced some inconsistencies and uncertainties about patent rights and their enforceability. While there have been some positive developments, AIPLA is concerned that the balance of U.S. patent policy is tilting in the direction of limiting enforcement rights, which may lead to a negative impact on R&D investment and reduce the innovation that produces such dynamic competition in U.S. markets. Governments like the FTC, governments through agencies like the FTC have the power to promote or discourage innovation through policy. AIPLA believes that IP protections are important to accelerate technological progress and economic growth, and we submit that careful consideration of the impact of these changes is warranted, and we thank the FTC for doing so through these hearings today.
Thank you, Barbara. And finally, we'll hear from Patrick Kilbride in opening.
Thank you, Suzanne, and thank you, John, and to all the commissioners for hosting this opportunity. Again, I'm Patrick Kilbride. I'm the Senior Vice President for the Global Innovation Policy Center at the U.S. Chamber of Commerce. The GIPC is the dedicated voice of the Chamber on issues of intellectual property-driven innovation and creativity. And I want to share up front, 3 principles that really form the premise for my comments today. Number one, that labor and capital invested in the creation of intangible assets deserve no less property right protection than labor and capital invested in the creation of physical assets. So in today's economy, we see that intangible assets like R&D capabilities, workforce training, business processes form a much greater share of market value than physical assets like plant and equipment and real estate. So it's appropriate that the U.S. is a leader in protecting intellectual property rights, which is a critical subset and a pivotal subset of that broader class of intangible assets. Number two, that exclusivity, exclusive rights to a discrete work should in no way be conflated with a monopoly. And number three, that the brilliance of the U.S. system is that it has recognized that strong property rights in both physical and intangible assets yields more productivity in the intangible space and innovation and creativity and more competition. So this was explicitly recognized with a great deal of foresight in the U.S. Constitution. And as a result, the principle that authors and inventors should own property rights in their work, no less than in physical assets, has underpinned the dynamism of the U.S. economy from its outset. Intellectual property was not an invention of the American founders, but America did democratize it in a very meaningful way, making it available and broadly accessible to inventors of every class. And that changed the system, making it the envy of all the world. Periodically, there are attempts to diminish the founders' vision by conflating that exclusive property right with a monopoly. But common sense tells us that Walt Disney's exclusive right to the reproduction and distribution of Pirates of the Caribbean, for instance, is no more a monopoly in the movies than your title to your car is a monopoly on automobiles or transportation. And in fact, the FTC and the DOJ in licensing guidelines have long held that they do not presume that a patent, copyright, or trade secret confers market power upon its owner. And this basic premise, though correct, I think it actually improperly suggests a correlation between the two. And we think the FTC should consider going further to clarify that in general, intellectual property rights in and of themselves do not confer market power. I think there should be no doubt in the minds of the commissioners that intellectual property rights are pro-competitive, that they protect against unfair competition and free riders, and that the existence of exclusive rights has long been considered and understood to be distinct from market power. And that's because the power of that property right to stimulate innovative and creative activity really hinges on the ability to invest at very early stages in that intellectual capital formation that provides a pathway to development, testing, and ultimately commercialization of a new and useful product. And in an environment where those property rights are protected, we consistently see more innovation, more creativity. Where they are less protected, we don't see as much. That scenario, unfortunately, is the reality in much of the world today, where intellectual property standards are very low. And such a routine infringement is a form of market failure for the innovative and creative sectors, and could even be considered an unfair method of competition. What does this mean for the United States? Throughout a period of intense globalization of international markets, the absolute and relative strength of its intellectual property laws gave the United States a competitive advantage and made it the world's economic engine. Now, following decades of globalization, the productivity edge in those sectors has been dulled, especially because our trading partners do not respect property rights at the same standard that we do, creating an unfair playing field for U.S. innovators and creators. So we've sought at GIPC and the Chamber a global commitment to enact and enforce intellectual property rights at a higher standard, one that empowers the creative capacity of all the world's citizens. That's why for the last 6 years, the GIPC has published its International IP Index, which is a comparative law analysis allowing like-for-like comparisons among, at this point, 50 economies across a range of categories of different intellectual property rights. And the data accumulated in the index provides a clear evidence of a strong correlation between Number one, the standards of a country's intellectual property system, the strength of their standards, that is, and its innovative creative output, its access to innovation and creativity, and a whole host of other socioeconomic benefits, including job creation, knowledge-intensive industries, and many others. However, on the global stage, we continue to see efforts to reduce intellectual property rights to the lowest common denominator, and among them, competition policy principles are being misrepresented and abused in order to deny U.S. innovators and creators the rights they deserve. What happens at home matters abroad. The U.S. is watched very closely by its counterparts around the world, and we need to be careful about the signals that we send. We're here looking at the period from now since 2011, and naturally the 2011 report of the Commission forms a focal point for that discussion. And whether or not you think that the 2011 report got it just right, the fact is that it was picked up and used by other actors in global markets in ways that have disadvantaged U.S. innovators and creators. So where it's very possible in the U.S. with our judicial tradition, our legal context, to take a nuanced and complex approach to these issues, we have to be very careful about the message that we're sending to the rest of the world. In similar fashion, 7 years ago, the U.S. Chamber supported enactment of the 2011 America Invents Act, creating the Patent Trial and Appeals Board. Concerns related to patent enforcement abuses were at a peak, and it was important to a well-functioning system that those be addressed. In its implementation, however, we see some overcorrection. While the U.S. maintains the highest rated overall IP system in the world, including on our index, where the U.S. scored 37.98 points out of a possible 40, there have been concerns in some industry sectors regarding restrictive patentability standards, the threat of patent litigation abuse, and legal uncertainty regarding the durability of patent rights. We think that this does a disservice to our innovative creative economy because it dampens enthusiasm for that initial investment. In a similar fashion, the good news is that recent steps by the U.S. Patent and Trademark Office have taken important steps to address some of these concerns, and we look forward to continuing to work with the FTC, with the USPTO, and other stakeholders to make further progress. Similar attention is due to the modernization of Copyright Office operations, as well as to addressing the global scourge of counterfeit and online piracy that threatens both U.S. consumers and its jobs. In all of these activities, the Commission has a critical role to play in upholding the constitutional promise of intellectual property-driven innovation and creativity that has served the United States so well. And we believe that a nuanced and sophisticated approach to regulation is not exclusive of a strong, clear, unequivocal political commitment to property rights. A fair and competitive marketplace demands no less. Thank you.
Thank you. We're just going to move into questions now. And the first question builds upon the remarks of several of the panelists, which is, what, in your experience, is the role of the patent system in promoting innovation today? Perhaps, Patrick, if you'd like to begin, and then we can invite others to join as well.
Thank you very much. So, the fact is that, as I just sort of reviewed, we believe that the ability of the patent system to stimulate innovative work is only as strong as the system produces rights that are reliable and durable on the back end. So that means that we need to do everything in our power not to address symptoms when we see those in the system, but root causes. So, when you hear about claims of over-patenting, claims of poor quality patents, the answer is not to make it easier to invalidate all patents. The answer is to spend the resources necessary and the attention necessary to address those problems on the front end. So I know we heard this morning, for instance, from Georgia Tech, been some very interesting ideas about the application of machine learning and AI to patent examination. But the point is, we cannot afford to just make it easier to invalidate a property right. We have to get examination right on the front end, as Barbara said, to restore that presumption of validity so that innovators can rely on the patent as a holder of value as they make long-term, high-risk, capital-intensive investment decisions.
Thank you. Would anybody else like to join in? To hear?
I mean, I would say that the whole patent system and the idea of innovation has become so muddied that we need to really understand what do we mean first by innovation. I think when we look at the patent system, it started off about invention, and I think in the 60s the language of innovation came about. And you can probably check the text for that if you look historically. And innovation is a great driver of economic growth, but that does not mean that it's deserved of a patent. Innovation encompasses so many different things: marketing, design. It doesn't necessarily mean inventiveness. Now, if you want to call the label what it is, if you want to say the patent system's not just about invention and it should be about all these other things, then perhaps we need to really start speaking what the value we put on these items. Because the cost to society is far greater when we give these, if you want to call them exclusivities, but when you see the strategies at play, they become monopolies. So I do believe that the patent system is in need of correction, and the definitions that we use are important in the narratives that we frame.
I have a more pedestrian observation, just real quick. Like from the perspective of our kinds of companies, when you ask, like, how do we use patents and why are they important? I would say there are three simple answers. First, to us, they're important for licensing, partnering, and for transferring business assets and intellectual assets, right? So you use the patent instrument for orderly dissemination of technology and getting partners. Second, they're important, of course, for investment and access to capital. And third, this is an observation I very often hear from our member companies, that with all the other uncertainties that are baked into the business model of, when you develop products that more often fail than not, and where you have to sustain investments of hundreds of millions of dollars or billions of dollars over a decade or longer, there are so many other uncertainties already built into that decision that adding additional IP certainty in the by changing laws or by court decisions actually become very highly leveraged in business decisions. You might say, really, our business is going to change their behavior just because there's a 10 or 15% increased uncertainty on the patent assets? Is that really going to change the course of the tanker? And it might, right? Because you have to think of it as being leveraged and layered on top of all the other business uncertainties that exist until a tipping point is reached. And companies, I've heard myself, from colleagues in the industry who have said, we make our business decisions when IP changes, we might as well go the other way on a development program, and we might not go with a high risk, maybe highly innovative program, but we're going to invest and go and take forward another development candidate that is perhaps less innovative, but promises less risk as well. So that, I think, is often what I hear about the role of the IP risk in the industry and how leveraged it can become in corporate decision-making.
Thank you. Matt?
I'll add something which, sadly, I think echoes statements that were made in the hearings in advance of the 2003 FTC report to promote innovation. And so in that sense, it seems some things haven't changed. But in recent years, surveys and empirical data on venture capitalists have indicated that the over-patenting or uncertainty around patent rights has a substantial negative impact on the willingness of VCs to put investment in a particular sector, and that's particularly the case in tech. And the availability of patents, by contrast, to a particular startup has relatively minimal positive improvement, and so it's regrettable that we appear to be in the same place we were back then. But so in that sense, I think it's similar to what Hans was saying, is that the IP system does impact investment decisions, and clearly it affects different industries in different ways.
I'll just add a little bit to that. We have members who are entrepreneurs or who are representing entrepreneurs who need to raise venture capital, and what we hear from them is they need patents in order to get the venture capitalist's attention. You can't take a trade secret on a roadshow. You need to have at least your patent applications on file, if not at least one issued patent, to obtain the investment to take the technology through to commercialization.
Excellent. Well, in many ways, I wish we could kind of meld this panel with the venture panel that we'd had yesterday, because I think there's some interesting parallels and some interesting sort of maybe change points. But one other thing that we've talked about so far on this panel is the IP licensing guidelines and in a little bit the 2011 report. And since our focus here is with innovation, I'm going to paraphrase the beginning of the 2011 report, which says that innovation is key to meeting society's unmet needs. It is risky and complex and includes a number of steps from sort of idea to development. And we talk about the role that intellectual property plays in promoting innovation, because it protects investment and protects the ideas from copying. But we also talk about the role that competition plays in promoting innovation, because it drives others to enter into the market. And so I say that because my next question is really, in looking at the years that have passed since we issued the Evolving IP Marketplace Report in 2011, how has substantive patent law changed in ways that are relevant to your members? And how is this influencing incentives to innovate and invest in commercializing technologies? And if possible, I'm interested sort of in how you are striking the balance between patent protection and competition and the roles that those play in promoting innovation. So I think we'll start with Barbara.
Okay, thank you. First, I want to say that I think by the time the AIA was enacted, the dialogue definitely surrounding the need for increased certainty in patents in the patent system had all come together and aligned. I mean, I think one of the purposes of the AIA was to eliminate some of the uncertainties that we were seeing in the patent system and to improve it. And the switch to the first inventor to file system really represents, I think, the culmination of that consensus about the need for additional certainty. So, that's definitely a positive. Unfortunately, I think we've seen some other developments that have led to more uncertainties in the patent system. Certainly, some of those uncertainties surround the PTAB, which I discussed in my opening comments. It's caused, I think, the uncertainties around the PTAB have led to significant costs and inefficiencies as patent owners and other stakeholders figure out kind of the lay of the land with the PTAB. I think it is stabilizing a bit. We are seeing some improvements with the clean construction rulemaking in particular, so that's going to eliminate some of the uncertainty and some of the inconsistency between district court litigation and the PTAB, which is very good news. The concern about serial challenges, I think, is still very real, and how to manage the situation around a potential standing requirement, particularly to the extent there's any uncertainty surrounding, what happens when a decision from the PTAB is appealed, and is there standing to continue the appeal, or are we in a place where there's no appeal from particular PTAB decisions because of the identities of the parties? So there have been also a number of judicial decisions that I alluded to in my opening statement. TC Heartland on venue has upended some things. The Lexmark decision on international patent exhaustion. Akamai undivided infringement, but by far the most significant one for our members is the 101 issue. There's no question that that our members are extraordinarily concerned about that. It's very difficult to advise one's client about whether to file a patent application, what the outcome of that patent application would be. And in some ways, the 101 situation is an interesting kind of case study for some of the other places where substantive law has changed, right? So we're in a place where we have a patent system where you file a patent application, you disclose publicly what you believe your invention to be, and the quid pro quo is that you, based on what you understand the law to be, will obtain some patent protection. It may not be the scope that you had originally hoped for, but you get some patent protection. That's the quid pro quo that our system has been based on for many years. And we've seen the benefits of that. We've seen the disclosures that are out there encourage other entities in the marketplace, including sometimes one's primary competitor, to design around. And some of the big technological innovations that we've seen over the years are, in fact, the result of the design around of the first, patent or patented invention that's out there. And so that's very concerning, and the Section 101 law situation has certainly exacerbated that problem and led our members to be concerned about whether patent filings will continue or whether we'll start to see companies maintaining more trade secrets. And of course, if something's maintained as a trade secret, it's very difficult for innovation to build on itself in that way. And so we have seen and heard expressed from our members that this 101 situation is really discouraging investment and innovation in certain areas, especially those involving artificial intelligence, healthcare diagnostics, and personalized medicine. And there's a real concern that this is going to shift innovation and the innovation activities outside of the United States to other countries. And I'll leave others on the panel, I think, to discuss maybe the details and the data around the filings that we've seen around the world. But there are some studies out there, including those that we've cited in our 101 report, that suggest that that applicants aren't able to get past the patent subject matter eligibility threshold in the United States, but are obtaining patents around the world on the very same invention.
Well, thank you, and I want to open this up to the rest of the panel, and just sort of noting the time, one thing I want to sort of flag for people going forward is I hear a lot that, if we don't have patent protection, we're going to move to trade secrets on the one hand, but then I talk to others who say, well, actually, they cover very different rights, and they're very complementary. So I think I probably can't ask you that follow-up question right now, but I'd like to sort of raise that for people who are commenting on this, because I think it's a very big question. Unless there's something you want to say quickly, because I don't want to prevent you from talking about that.
Thanks.
So I'll open it up to the rest of the panel.
So let me jump in there. You mentioned the intersection, I think is very appropriate for the FTC to be contemplating is the impact of IP versus competition as a vehicle, a mechanism for promoting the public welfare. I think they're both appropriately regarded as critical tools in the innovation promotion toolbox. All those tools should have clear substantive boundaries around them. And you don't use a hammer to drive a screw. And we see these kinds of fights happening outside the IP space. Right? There's a lot of discussion now about using competition law to solve non-competition issues, because the non-competition issues are regarded as subjectively important, and competition law looks like a pretty powerful hammer to use. And so we need to make sure that areas of the law stay in their lane for design purposes. And in many ways, I think our recent 101 jurisprudence is doing precisely that. I would note on the matter of, serial challenges, which comes up rather frequently, the PTO does have complete discretion over whether or not to institute these. And so to suggest that this is a huge problem implicitly suggests that the PTO doesn't have the capacity to exercise that filtering function, which I think is a hard argument to justify. And secondly, it's my understanding that only about 15% of patents are subjected to IPRs, and I'm sorry, more than one IPR, I think that's right. And the majority of those it's only 2. So I submit that may be overstating the problem, particularly when, as I mentioned in my preliminary statement, our European counterparts actually appear to invalidate or modify at a higher rate in their opposition proceedings than we do. Overall, I think the way the system has changed, I mentioned previously IPRs and these subject matter reforms. The ways that the patent system has stayed the same are equally important, and some of the data that we saw earlier today has shown that many of the problems that are regarded around patent assertion entities have stabilized. They have not gone away, they have stabilized. And insofar as we regarded that as a problem 10 years ago when we started talking about the patent system, and the data points are where they were 10 years ago, I'd submit we have more work to do.
Hey, Suzanne, maybe I could jump in on the question you raised about patents and trade secrets. Just to share some observations from someone who works with a really diverse set of businesses and industries. I've seen a bit of a breakdown, on 2 levels. One, you talk about inventors, and there's obviously a huge difference between an inventor who's housed in a large multinational corporation with incumbent market power, and a small inventor working out of their garage, investing their time and their money in a startup. And to one, a patent might be a little more than bragging rights, but to the other, it's a business model. So that's one thing. I mean, the other level that we have to consider is the way companies use their intellectual property. And I've seen a breakdown in the companies that we work with between the industries where intellectual property is part of the platform and really does stay within the company, and those where the intellectual property is necessarily housed in their end product. And so that, leads to some different commercial decisions. What I think we want to avoid, in terms of promoting the national welfare, is making decisions based on commercial considerations versus those fundamental economic principles. And so that's where some of our arguments are based.
Just real quick, because you asked about changes in substantive patent law that affect our members. Of course, Section 101, that's the one we hear about most and most consistently, but it's not the only one. There are other areas. Written description for antibodies under Section 112 is kind of peculiar to our industry. Non-statutory double patenting. So a list can be compiled of legal changes that over time, I think, now implement different rules from the ones that existed before. The reason why I bring this up, and don't want to let it go unsaid, is that people consider these changes and these Supreme Court decisions and court decisions mostly in the context of what it means for procuring more patents in the future. What does it mean for the patentability of new innovations? And what sometimes is forgotten is their impact on issued patents that have been around for a long time and on which people have relied to build their businesses. The proposition is, really, if you flip the timeline, is you could tell an entrepreneur today that congratulations, you have just applied for a patent and been granted one. You have complied with all the rules. We all did a good job, and with the expenditure of much effort, you can be pretty confident that you have a good patent today. Go and build your business. In 10 years, when it matters, and when that patent might be reviewed in the context of litigation, we may apply different standards to assess its validity than the ones we just applied when it was granted. You will not know what these standards are. But go ahead and invest and build your business. We'll see, maybe you can hang on to your patent in 10 years, or maybe it will be declared bad because the law changed along the way. Nothing could be worse for investment in innovation in that. And Section 101, as Barbara said, is only one example. I think we've had a range of those. And we really have to like consider the impact on granted patents and the speed at which businesses learn their lesson. Because when this happens 2 or 3 times, and then when it happens to them, I think they will go back to their patent counsel and other people and ask, patent, fine, is there something else I can rely on that will give me the certainty that I need? Because this is a crapshoot, and if they are going to keep changing rules on us, we need to find something outside the patent system that will give us that assurance or change our investments in a different direction.
Sorry, we're just checking our time here.
Yeah.
Yeah, I think that's fine, yeah, because it gives him a chance to, yeah.
Great. Well, earlier today and also in our discussion right now, we've heard a lot of mention of both the PTAB and the new IPR proceedings. So my next question is, in your experience, what has been the impact of the AIA's creation of the new IPR proceedings administered by the PTAB? I'll start with you, Hans.
Mm-hmm. I want to make reference to many things I heard in the earlier panels this morning, which talked a lot about the PTAB. So one observation that I get very much from our members is, yeah, the PTAB was created. You know, its stated purpose was to serve as a more cost-efficient and quicker alternative, a substitute, if you will, for district court litigation. Right? And manifestly, this is not the experience we have in our membership. I talked about Hatch-Waxman litigation earlier. That is the largest proportion of IPR-related litigation that we have in our industry. In those cases, in drug cases, we know empirically that they are virtually never stayed when there is an IPR. So district court litigation is not being stayed. We're aware of 2, maybe 3 pharmaceutical cases that actually received a stay when an IPR was instituted. Overwhelmingly, what we do see is that they operate as parallel adjudication. A typical scenario is that a generic company, drug pharmaceutical company, so this is not only small molecules. Picture is different for biosimilars, but for ANDA litigation, generic drug companies file their paragraph 4 certification with the FDA, which means they have a time point at which they have a pretty good idea of what's wrong with the patent or what they think is wrong with the patent. Then the patent is litigated for about a year. Then the IPR challenge comes. And if it's timed right, because Hatch-Waxman litigation is not stayed and is supposed to be on a 30-month time frame, around the same time period at the end of the IPR, the district court litigation likewise will come to a conclusion. And so the effect is that there is an opportunity to hedge against the result of the district court litigation. And if the district court upholds the patent, maybe the PTAB will strike it down. Even if they both agree that the patent is not invalid, there's an opportunity for not 1 but 2 appeals. Right? So there's a lot of duplication built into the system, baked into the system as it pertains to pharmaceuticals that wasn't contemplated when the AIA was negotiated. And without opining on other experiences with the PTAB system in other industries, I think in our industry, given the duplication of adjudication that it produces, IPR serves some kind of function that wasn't contemplated when the AIA was negotiated. It certainly doesn't unburden the district courts.
Hans, I just have a clarification question. When you're seeing PTAB district court proceedings that are not stayed pending PTAB review, is that localized within certain districts, or what's the reasoning for that?
There's always, I think, concentration in certain districts, because if it's Hatch-Waxman litigation, this is the one we understand best, that unfolds in maybe 3 districts in the country. It's mostly Delaware, some New Jersey, and a few other places. It's not the courts. Yeah. I think it's an expectation that these litigations by statute are supposed to proceed under a 30-month timeline. So I do think that judges who handle these Hatch-Waxman cases feel that they ought to proceed because everybody's waiting for a result. The FDA might want to approve the generic drug, but can't do so until after the expiration of 30 months or resolution of the litigation. So there is a sense that there's benefit to resolving these disputes, at least promptly, without sitting around for a year and a half and waiting for the result of an IPR. And keep in mind, right, the kill rates in IPR aren't what they used to be at the very beginning. So there's a pretty good prospect that if a pharmaceutical patent or a biologics patent undergoes an IPR, it might emerge with claims intact at the very end. And then we're just back in district court, because invariably the defendants have other defenses that they couldn't have brought in IPR and that they reserve for a second round of litigation in district court. Right? So I do believe that judges often feel there's a risk that the IPR is going to lead to more delay than expedient resolution, and it's going to cause duplication of effort rather than unburdening the district courts.
Thank you.
Thank you. Well, keeping on the time, I'd like to give some of our other panelists an opportunity to respond prior to the conclusion of our hour. So perhaps Tahir, would you have anything to say in response?
Yeah, I just want to take a step back a little bit, just looking at the broader system. It's kind of ironic that we hear the complaints of serial challenges, yet we have serial continuation applications to get a patent in the first place. So if we're talking about front-end problems, there you have a front-end problem straight away. We might not end up in litigation or these investment issues if we solve these matters earlier. The other thing that I find interesting is there was an FT article that talked about how the branded pharmaceutical industry uses a PTAB quite a lot. So on the one hand, the branded industry, pharmaceutical industry, is complaining about the PTAB, but then on the other hand, it uses it itself. It seems to me to be kind of hypocritical to not want the PTAB or try and diminish it, but on the other hand, to try and use it as much as possible when they need it. And I think this is where having the PTAB and having a strong IPR system is important for a democratic patent system. And we've heard the issue of standing being a problem. I think there's a lack of standing in courts when you think of who can actually bring a patent invalidation in court. Consumer people, groups, public interest people are not allowed to have standing in courts unless you're infringing the patent. What kind of patent system is that? I don't believe that exists anywhere in other Western developed countries where you can't actually have the right to stand and bring an action. So when we talk about these issues, let's look at it in the broader sense. We hear a lot of these complaints about what the industry needs, but I feel we're gearing towards where the term innovation has become a monopoly power. Anytime you use the word innovation, it should be overprotected. And personally, I think the IPR and the PTAB system is a minuscule check on some of that, and it's actually being whittled away, particularly because the industry, the pharmaceutical industry, tried to extract pharmaceutical patents in 2015 from the IPR system. So it already showed that it didn't want it, so it hasn't really allowed it to work. And we've seen it scale back, and even Director Arianko in his speech the other day, where he's calling it balance, but he's really saying anybody who's talking about patent abuse is really anti-innovation. So I think there's a lot of work to be done.
Great. Thank you. Would anybody else like to speak to this?
Let me say a word about IPR, and while I can't comment on the Hatch-Waxman issues that Hans was referring to, I know from our perspective, IPR has provided a very cost-efficient procedure for determining validity before an expert tribunal, as opposed to the alternative where ultimately you can wind up determining validity before, at best, an inexpert federal judge who is skilled but a generalist. And having the opportunity to move these validity questions to an expert agency of judges trained in the law and the technology has provided extraordinary cost savings over the alternative of doing that through civil litigation, which isn't to say it's free. The IPR processes are expensive, but our back-of-the-envelope calculations is that billions of dollars, literally, in litigation costs have been avoided due to the PTAB's processes, and that's critical and due exclusively to the availability of a mechanism for assessing validity that's not in federal district court.
Thank you.
Maybe I could just add that, again, repeat that the U.S. Chamber supported the act that created the PTAB, that we see value in a mechanism that provides a time-effective, cost-effective alternative to the courts. However, it's important that it's in its operation, it doesn't undermine the reliability of patents as a store of value, such that businesses are able to make long-term investment decisions. And in its operation over the last 6 years, I think a number of the problems that have been raised today are significant. The serial nature of challenges, which does exist, the differing standards from the courts, and the reality that unless a patent holder gets a final written decision affirming their claims, that they have no certainty throughout the life of the patent. And that's a real problem for our system. USPTO Director Iancu has taken some steps to make this work better. We're interested to see how they work and want to work with all industries to make it as useful and effective as possible while retaining that strong store of value in the U.S. patent.
Thank you. Barbara?
So I just want to add a couple of things, and this is really more from maybe my own perspective as a patent litigator rather than speaking on behalf of the association. But, you know, we can talk a lot about the data and how many serial challenges there have been or not. The threat of redundancy, however, is one that I have to address with every client I speak with who's considering enforcing their patent rights. And that's changing the calculus of the decisions that patent owners are making about whether and when potentially to bring a district court litigation, knowing that even if they assert one patent, they could face several petitions directed to the same patent in addition to the district court litigation. And if those petitions are filed just before the one-year bar, it's highly unlikely that the district court's going to stay the litigation, and the defendants actually may choose not to because it's part of their litigation strategy to run up costs. So something to be aware of, and I'll just throw out with my AIPLA hat back on that according to our economic survey, the average cost through trial for a single PTAB proceeding is not cheap. It is $324,000. This is something else to think about.
Well, thank you. And given the time, I think we'd like to shift into giving everybody the opportunity to make probably 2 minutes of closing remarks. But as we do so, we received a number of questions from the audience, and there's one in particular I think is rather good, and perhaps you can think about it as you make your closing statement. And that is, what is on your patent policy wish list as we gear up for the next Congress? So I invite you to respond to that or make any other statement that you'd like, perhaps going down the line, beginning with you, Barbara.
Well, I think I've already shared a piece of that. I think the Section 101 legislative reform is something that AIPLA has been speaking about with IPO and with other bar associations and others in the industry. I think that that's a particularly important reform effort for us. That's the one that's kind of the top of our radar screen at the moment. And let me just close really by thanking you all again for the opportunity to have this discussion. I think that all of us here have benefited from it. And there are a lot of cooks in the kitchen. As someone said this morning, there's a lot of pieces to this puzzle about the changes in the patent landscape. And we just encourage you to be comprehensive in your studies, incorporate a range of perspectives from the various stakeholders, and collect data on all the trends across all the sectors in order to really assess the legal landscape. And we thank you for your efforts in that regard.
Great, thank you. Matthew?
So let me try and answer the question and sum up at the same time. I think for the reasons I've mentioned before, the highest value that can come out of patent policy right now is, I think everyone would agree, increasing the certainty for all the stakeholders in the system. We view one particular way of doing that is to improve the output and quality of PTO's work. Obviously the PTAB is one mechanism by which that is done. Having greater certainty around subject matter is another vehicle. And whether those are legislative wish items or just generic wishes, I think is, I'll leave open. But those are something that I think we can all agree is a shared objective. And hope we could find ways to pursue that next year.
Thank you. Hans?
So my wish for next year, I think there's been too much patent reform too quickly. And so I think what we should have over the next couple of years is that we take a breather to work through the substantive implementation of the AIA. I hope that the scope of patent-eligible subject matter is going to settle, but I'm just going to second Barbara there. I'm not optimistic that this is an area of the law that the courts can develop and that's amenable to like good judicial development. On the PTAB side, I wish for harmonization of legal standards with those that apply in district court. I think adjudicators of issued patents should use the same legal standards. A patent should mean the same thing to different adjudicators, and it should be upheld or struck down on the same quantum of proof. I think that's only good policy. I would hope that we can take steps towards that. But overall, I think I'm hoping for a breather and for the system to recalibrate and kind of calm down. We don't need more patent reform too soon. I think we need incremental change. And I think we're taking good steps. I think this current administration and patent office leadership is working in the right direction, and we were encouraged to see the level of public support that Director Janko and patent office leadership seems to be gaining and gathering for their current initiatives. We hope this will continue.
Thank you. Tahir?
Just to piggyback off what Matt was saying, I think we need more quality coming from the USPTO. And I think one of the ways to do that, my wish at least, is that we really start looking at the obviousness standard. I think post-KSR, despite that providing a little bit more clarity, the courts have never really applied it in any real way. And I think we barely have an obviousness standard. It's just marginally, slightly more than a novelty standard. And I think more patents are being granted just on the basis of utility and meeting an unmet need than actually having real inventiveness. So I would like to see a stronger inventiveness standard that would actually eliminate many of these arguments that are going on in terms of litigation and fluctuation and investments and so on. I think there isn't actually enough patent reform. I think we need more. It hasn't gone fast enough, and that's why we're in the predicament we're in, where we're having more monopolies today than we've ever had since the Gilded Age. And that is a fundamental problem for society, and it's also a problem for innovation as well.
Thank you, Patrick.
Yeah, thanks. I guess if topping my wish list, I would have to look externally to the role that the U.S. plays in the global economy, and I think it's incredibly important that the U.S. really step out and lead the creation of a global system that empowers innovators and creators everywhere to develop their latent capacity. 25 years after the WTO TRIPS agreement was created, we still see vastly different standards of intellectual property treatment around the world. Only a handful of countries protect intellectual property at the standard that the U.S., the U.K., and a handful of other countries do. And those countries are disadvantaging themselves both in terms of their innovative output and their access to the innovative products, services, and technology of the U.S. and others. It's absolutely critical that the U.S. speak with a clear voice, that it be a champion for certainty, and that we not send mixed signals. So I'd really like to see everyone rally around the system that has gotten us to where we are today. We're better off than at any time in history across all sorts of different metrics, and we can't forget how we got here. Thank you.
Great. Well, thank you, and I'd like to thank our panelists, and we're now going to take a short break and resume at 3:15.
Thank you very much.